Yes, Mr. Hewley. Are we very slightly early?
If it was 5-2, my watch says it's 3-2. So
good.
I'm not going to take a point on it.
No, well, fine, as long as we're not starting early. Yes.
Thank you. My Lord, just before I continue with the exercise that I started in relation to the law, and there's just a couple of authorities, I just want to come back, as one often does, and pick up on some questions that arose during the course of argument this morning. And I'll put it, the global question, which was asked, I think, possibly more than once in different ways, but the global question was, well, what else could the Council have done? So just with that thought in mind, a couple of quick points, which I didn't have at the forefront of my mind, or in some cases at all in my mind, when the question was asked. But so the first point is just this. So in relation to the gathering of information about numbers of disabled persons and numbers of disabled persons reliant on cars in particular, there is, on the face of it, a very simple answer. Because the Council is responsible for managing the relevant blue badge scheme. As a disabled person who says, I rely on a motor vehicle because of mobility problems and I need a blue badge, you apply to your local authority. They will therefore have a list of everyone to whom they have granted such a badge, which ought to be pretty much everyone in their area who has such a badge. The badge can be relied on outside of the area, but the Council administers the scheme. So the short answer is, should be the easiest thing in the world to get a very, very clear idea, not necessarily, as I say, of every single person, but of the type of the numbers and indeed locations, as far as we can see, of those with those kinds of needs.
And the blue badge scheme applies broadly, at least, to...
So broadly, I mean, the underlying purpose of the blue badge scheme is to recognise mobility problems which make you more reliant on the car. So you need to be able, for example, to have a parking space outside the supermarket or outside the front of the supermarket. Or
so
that sort of thing.
It's relatively broadly cast in that way, yes.
Yeah, but it would give an immediate snapshot of the kinds, the nature and indeed locations of those.
All right.
That's an obvious thing they could have done. I'm not suggesting that was the only thing they could have done, just to illustrate there's plenty of things they could have done. Secondly, I made the point, and indeed I said I'd take you to the reference, and I'll do it very quickly, that another thing they could have done was consult with disability groups, and there's some references on this I just want to pick up. So Mr. Phillips himself, this is the Council's witness, albeit not the decision maker, makes this point. It's in his witness statement, which is in tab 4 of the supplemental bundle, and I optimistically perhaps think that the pagination at this point may correspond to yours. Okay. So if it does, I want you briefly to turn up page 53 in tab 4, but at any rate it's a heading above paragraph 36.
Page 33.
Oh. So much for that.
It starts at page 30. So which paragraph?
So I've got a paragraph 36.
36, yeah.
There's a heading, Council failed to comply. And the section which follows, and I just want one paragraph of it, is dealing effectively in a rather pleading type way of various points made in the claim and the letter for claim relating to ways in which the Council failed to comply with the PSED. So if we just turn the page and go to paragraph 41, Mr. Phillips says, in respect of paragraph 70 of the Statement of Facts and Grounds, the Council denies it has not engaged or required information from disabled residents. The Council has engaged with disabled residents, so his case is they can, presumably, and indeed can do by consulting, because he goes on, evidence by consultation with Wheels for Wellbeing, Commonplace and so forth. Now, it's not completely clear, but Commonplace is not another organisation, I think it's a website or something you can have, it's a sort of social media place. So the consultation is just with Wheels for Wellbeing. 2 points about that, which we can make good by going to the witness statement of Isabel Clement, which I hope you have behind tab 3.
Yes.
The first is the specialist nature of Wheels for Wellbeing. I make clear, I don't for a moment doubt indeed I'm happy to say they're an entirely laudable organisation. But they have a very narrow focus. So paragraph 4 of her statement, first page behind tab 3, I hope. Wheels for Wellbeing is a charity based in Lambeth. They're based in Lambeth. but they're a national charity, so which exists to ensure disabled people realise they can cycle, and who campaigns and advocates on behalf of disabled people who do. We provide opportunities for disabled people to try out and practice cycling in South London, etc. We further support disabled riders through lead rides and develop inclusive cycle hire services. As I say, completely laudable, obviously, but a very specific focus, which will be relevant to disabled people with particular characteristics, namely those who can cycle but perhaps don't do it as much as they wish to. Obviously not my client and lots of other people. So the council, bearing in mind the point I've made about the wide nature and the varied nature of the needs of disabled people, problematic in my submission to consult only with a group of that nature. But anyway, it certainly shows that if the council could consult and could get better information, and I'll make that proposition good further away in a moment. But just while we're on this kind of statement, if you then go, please, to paragraph 15.
Yeah.
I'm not going to venture the page number.
Yeah.
And I should say, quite a lot of her statement is taken up with why she, after the event, thinks these are good schemes, and so be it, but it doesn't help us. But paragraph 15, Wheels for Wellbeing were approached and consulted specifically about 3 temporary schemes. And then you'll see a possible temporary cycle lane, A, B, temporary cycle lane, and C is Rosendale Road temporary cycle lane. So her evidence, contrary to Mr. Phillips, so Mr. Phillips says we can consult and we discharge the duty to do so, or we discharge any need to do so by consulting with Wheels for Wellbeing. Is actually they didn't consult us with Wheels for Wellbeing on these LTNs. That's her evidence, contrary to Mr. Phillips, which is a much suspicion pretty bizarre. Now I ought to, just for completeness, draw your attention to paragraph 16. In general, we have found that Lambeth Council has been very proactive in consulting us about previous long-term plans. Our experience, and then there's a slightly odd sentence, our experience with regards to the emergency temporary let schemes, brackets, LTNs, etc. And then this is curious, has been that where they had time to, officers sought our views and mostly acted on our recommendations to ensure that cycling schemes were accessible to disabled people to cycle. So I don't understand that to be a claim that they consulted or sought the advice of Wheels for Wellbeing about the needs of disabled people. And in any event, it's where they had time. It's so qualified in my submission. So, frankly, contrary to Mr. Phillips' evidence that they consulted Wheels for Wellbeing. I mean, obviously, on some of them, they consulted them about something. Consult them on these LTNs. But equally, obviously, they're perfectly able to. And then the last bit of this jigsaw, as it were, is to go back to tab 2. This is the witness statement of Lauren Johnson-King. She is, and tab 2, first page, you'll see she is the director of Disability Advice Service Lambeth, DASL, as it's generally known. And they are an organisation, unlike Wheels for Wellbeing, which is not only located in Lambeth, but which is local to Lambeth in the sense it's concerned with the needs of disabled people in Lambeth, focusing on that. And it's general to disabled people, it's not focused on a specific niche, if that's a fair way to put it, niche interest. And of course, DASL weren't consulted, but Miss Johnson-King reflects on that in paragraph 20 onwards. And for reasons of time, I won't read it all out, but essentially the point she makes is we'd love to have been consulted. If we had been, we'd have been able to provide a much wider range of information to the council about the types of needs that disabled people might have and the range of different needs that disabled people have. So going on the question of what else could the council have done, well, actually, it's pretty obvious what they could have done. There's a charity in their area which is tailor-made to inform them on these questions, and of which they're perfectly familiar with in a general sense. Third aspect of this, what could they have done, is picking up on a slightly different aspect. Not so much what could they have done to inform themselves, but what could they have done to reflect the information so garnered. And of course, my client's case then is that these schemes are objectionable in principle. She prefers not to have any low traffic neighbourhoods, or at any rate none anywhere near her, and none in Lambeth. But obviously there's also an alternative, which is that you can have schemes which are designed in a different way and mitigated and so forth. And so one obvious answer to the what could they have done question is that they could have introduced some kind of exemption. I think Mr. Mould would say dispensation, I think that's his word, for disabled people, or blue badge holders, for example, to enable them to cross particular LTNs and so forth. And indeed, we now know they're planning to do something broadly along those lines. And it's not all or nothing. I mean, if the duty is there to ensure not only that when you decide in principle whether to do something, you take account of disabled needs, relevant protective characteristics, but also that in designing the scheme, you do so, and you identify suitable exemptions and so forth. There's an obvious answer in my submission to the what could they have done differently question. Now, in that regard, I think I should just pick up on one point arising from what Mr. Mould caught this morning. Because Mr. Mould, so as I understand what's proposed going forwards, is that there would be a dispensation, I think that's what he would say, there will be a dispensation for blue badge holders to enable them to apply for dispensation, exemption, whatever, in relation to their local LTN. But just so we know, certainly our understanding of that, is it will be, not only will be limited to the local LTN, so for my client Railton, for example, so she's not able to cross other LTNs, but it's also limited in another rather significant respect, because it will enable entry not into the LTN, but simply via one filter, one entry point. So if you think about my client's situation, she can now, going forwards, if that happens, she can turn left out of her cul-de-sac onto the main road and drive out through the LTN. When she comes back, she's still got to drive around. Now, I'm not inviting you to adjudicate upon whether that's a good thing or a bad thing, but I just think it's quite important you're aware of the pretty severe limits of what's being proposed even going forwards. Point for present purposes, having just corrected that, is it's another obvious answer to the what they could have done differently question. They could have, and if they were properly informed about the potential impact on disabled people, you might think it's an obvious thing to do in the context of the experimental scheme. They could have mitigated the effects in that kind of way, and no doubt in other kinds of ways as well, so that you don't have the blunt instrument of an experiment which is used to gather all the relevant information. Now, there's another point about this, which is that, of course, it's not really vulnerable to the experiment. I accepted in the course of argument this morning, and I do accept, that when it comes to knowing how traffic flows and so forth are going to change going forwards, you may well not be able to know with a great deal of certainty. But with respect, you can know. You don't need to do the experiment to know that my client can't, to take this particular example, that my client can't turn left out of her driveway, and that in that respect, regardless of general traffic flows, presumably half of her journeys are going to be significantly increased because you've got to drive right around this area. So that sort of point isn't dependent upon the experimental, upon the experiment or performing the experiment. It's precisely why, in my submission, these are all the issues that should have been thought about before. And again, our point is obviously that the council didn't do any of that. Now, I'll come back to the law and then my submissions. So I just wanted then to go to bracking. This is the only authority that I rely on positively, but I'll just say something brief about two other cases afterwards. So bracking is at tab 4 of the authorities.
Just a second.
It's a very well-known case in this area, so I won't say much about the context. There's a challenge to something called the Independent Living Fund. or rather the termination of the Independent Living Fund by the Secretary of State in 2015. I'm not sure we're going to get very much from the facts, so we'll go straight to the key propositions of law. So the PSED, the law relating to the PSED is picked up, if it's useful to do it this way, 87 of the numbering we've added. There's a heading towards it. Slightly, I find these double column reports slightly confusing, but you'll see on the left-hand column of that page there's a heading PSED. The section is then set out fairly fully, and over the page at 88 there's the well-known passage setting out some propositions. So paragraph 26, page 88, or 68 in the report, if that's more helpful. The court has that.
So paragraph, which paragraph?
Paragraph 26.
26, I'm so sorry.
Yes. No, not at all.
Yes.
Yes. And then Lord Justice McComb, I think it is, then sets out a series of, and I think Lord Justice Kitchen, Lord Kitchen agreed with him. Lord Justice Elias agreed in some respect on the facts, but I don't think in any material respect on the principles. Paragraph 26. As stated by Arden L.J. and Elias, equalities duties are an integral and important part of the mechanisms for ensuring the fulfilment of the aims of anti-discrimination legislation. That's a fairly general proposition, of course, but I take it that the importance of that is what it is saying is it's not a minor matter. It is at least potentially a matter of great significance and importance, and it should be integral to the decision making. 2 is about recording steps. It's irrelevant, but I won't read it out. 3 is critical, and it goes to a question asked that arose from a question my lady this morning. The relevant duty is upon the minister or other decision maker personally. What matters is what he or she took into account and what he or she knew. Thus, the minister or decision maker cannot be taken to know what his or her officials know or what may have been in the minds of officials in proffering their advice. That's the proposition which in my submission is centrally, I hope I fairly reflected this morning in response to my lady. The decision maker, the person tasked with making the decision maker, has to think about these issues for themselves. And
was that case, the health stores case, a Section 149 case, or a case about the predecessor duties?
It's a Section 149 case. It's 2015.
Right.
So does my lady mean the duties under the DDA and so forth?
Yeah.
Yeah, no, it's a pretty...
No.
Sorry, I may have misunderstood.
No, sorry, I didn't make the question clear.
Sorry.
The citation, which is said to support that proposition.
Oh, I see. I suppose that... I'm so sorry. Well, it's 2005, so I suppose that is a case under the predecessor.
But is the health case a case about those duties, or is it a case about something else?
My lady, we don't have the case
No,
in front of us, so I'm not going to try and answer that.
It's rather important. My recollection, I haven't looked at that decision for a while, is that
Yes.
that was a case in which civil servants knew various things, but didn't communicate them to the...
Yeah.
And actually, I think that statement might even be obiter. I think it's quite important, if you're going to pluck something out of another case, to know what the context
Well, my lady,
is.
it's quite important that I have not understood Mr. Mole to contest it.
Well, and the other the other problem about these supposed requirements is that paragraph 26 is introduced by a statement which there's no significant dispute about any of this.
Well, my lady, as in bracking, I don't understand there to be any significant dispute about these principles in the present case. If there was, I would have dug further and looked at the underlying case and so forth. But can I just draw attention, because it's the same point. If you look down the page, paragraph 26.5, there's a series of propositions taken from the Brown case. So in the same column, 26.5, Brown. By the way, Brown, perfectly right to say, would also have preceded the 2010 Act, but...
Yes, and Brown, amusingly, is a case where a lot of these propositions are advanced, but the decision wasn't quashed. It wasn't found to be unlawful, even though on the facts...
Well, sure, but that doesn't affect the authority their authority. I mean, Brown has been stood for a long time, as I understand it, as a statement of the relevant principles. The point I make is another way of expressing the same point. If you look at the Roman 1, 2, 3, 4, 5, Roman 4, the duty is non-delegable, which is another way of expressing the same point. The decision maker must appraise themselves of the relevant information. I must say, I mean, I have never understood this proposition to be controversial. It's not been put in issue before, either in the lower court or before you. Again, Mr. Mole will jump up if I've got that wrong, but I don't think it's being disputed. Which is why it seemed to me that a statement in a very well known and very much cited case to that effect would be an adequate basis.
I don't know whether there is some significance in the expression taken to know.
Coming back to 3.
Yeah. I mean, one would need to go and look at what Lord Justice Sedley said in National Association of Health Stores.
Maybe we should, and obviously outside of today we can go back and do some more research. But with respect, I don't understand there to be any great mystery, as it were, about paragraph 3. What it's saying is, this is a duty. If the person who's tasked with making the relevant decision, for whatever reason, they're the Secretary of State, or needs to, and here under a scheme of delegation, the way we've seen, needs to take these matters into account for themselves.
Yes.
And of course, that only reflects broader principles in any event, which is the decision maker must always, if you're the decision maker, subject to the Carl Toner principle, which of course makes things a bit more complicated, but doesn't apply to local authorities. If you're the decision maker, you need to take account of the relevant factors and matters yourself.
Yes, but there may be a difference in fact between officials in a government department knowing something and the minister in charge of that department knowing it.
Yes.
On one hand, and on the other hand, in the context of a local authority's decision making, officers other than the delegated officer knowing something and that being noted by the...
Yes. Well, there may be a difference.
Yes.
There could be a basis for a difference, but I think the important point is that if there's a difference, it goes the other way. Maybe that's why it's... Because, of course, in the context of central government, you do have the Carl Toner principle. Carl Toner has no role to play in relation to local authorities. So it's never the case. So in the context of in the context of central government, a decision which never goes near the minister is nevertheless taken in the name of the minister, and there is scope for him.
Yes, but this all arose.
But none of that applies to.
No, but the question, to be clear, the question that my lady raised arose in discussion of the passage in the October report, I think.
Yes.
At paragraph
yes, I mean, that's why it's important.
Paragraph 7.2, I think.
Yes.
Where you were seeking to differentiate between what Mr. de Sumnew knew and did on the one hand, and what another officer knew and did on the other.
And that's why, I mean, that's that's why I refer to it.
Whether the dicta of Lord Justice Sedley support that distinction, we would have to check, I think, by looking at...
Obviously, I'm very happy to try and undertake some further research. It may even be that we can have a note, or it may be that we'll...
The court's not asking for further research, but we're simply noting, I think, at least I'm noting, that I would feel reassured once I'd gone back and looked at what Lord Justice Sedley actually said.
Well, I'm very content to do that, and also to look at Brown, and indeed to see if there's any doubt about it, if there's any other authority. And I can see it's become... It's always, in my mind, been quite an important point, and it may have become a more important one. I do just repeat...
Even looking at Proposition 3 at face value, it seems to be more directed to information which is in the minds of the officials, but is not communicated to the decision maker, as distinct from a decision maker who relies on what he is told by subordinates.
Well, sure, that's right. And
I think actually that's putting it much more crisply than I did just now.
I agree.
Well,
I mean that I could have.
Well, I don't. I accept that. I mean, it's not. There's no difference. I perfectly accept that a decision maker can act upon information given to him, even when carrying out the equality duty in a locals or whatever. That's fine. Then one needs to look at what he is told. If he is told, here's the detailed EQIA which we have prepared, which does all the work for you, which works out all the pros and cons, then I perfectly accept it. I mean, the decision maker doesn't have to go off and do the research himself or prepare the EQIA. That's plainly right. And it can be then said, well, you've got the basis, you've got the material in front of you as the decision maker to conduct the analysis, and you're perfectly entitled to adopt or agree with the analysis which is contained and set out. But of course, that's not what happened here. Mr. Dissonmu, no, Mr. Mull doesn't dispute this, Mr. Dissonmu is not provided with the EQIAs, which in fact didn't to some extent exist in any event, and told, well, here's all the material for you to make your own decision upon. He's simply told that someone else has done it.
What would be the position if there was a perfectly good qualities impact assessment which covered all the points which you're concerned about, but Mr. Dissonmu was simply never told about it? He was simply told, well, we've done an assessment and we think it's all right.
Then the decision would be unlawful, there'd be a breach of duty. A point could perfectly well be made about relief in that context. But that's a different point. But on the question of has the decision maker had due regard to the... I mean, obviously, there might be another basis that says he's had due regard even without the EQIA, but subject to that. So let's assume that there isn't. So it's the only basis he could have done it is the EQIA. The EQIA
well, he relies on what he's told, which is that the exercise has been done and it's okay.
Well, then he hasn't done the exercise.
Yeah. Okay.
I mean, that's... In my submission, with respect, that oughtn't to be controversial, my lord, or my submission, because if you're the decision maker, I mean, this is a wider point actually than EQIA. If you're the decision maker, you have to do this. You're the person who's charged with the responsibility of taking the decision. If I can give you, I don't suggest anyone in this room would do it, but a judge who lets their judicial assistant, make the decision, and that's no good. As I said, I don't for a moment suggest that anyone can do it, but
you might get some very good judgments.
Present company should hear you saying that too. But getting back to the Carl Toner principle.
Yeah.
I mean, I would wish to satisfy myself, and I haven't frankly gone back and looked at the National Association of Health Stores case to see how Lord Justice Sedley relates that proposition to the Carl Toner.
Sounds like the court will perhaps do it, but in any event we'll do that and we'll supply with the cases, and if there's anything arising from it.
I must say, I've got a feeling that what he said was obiter, because I think. But anyway.
But I mean, even if obiter, it's not as if Mr. Mould is saying the contrary. You are entitled to follow an obiter remark. Indeed, it's persuasive. Distinguished member of the Court of Appeal. It's been adopted by a number of the members of the Court of Appeal as an important principle. I haven't obviously put them all for you, but this is a very oft-cited authority.
Yeah.
It's not generally regarded as controversial.
Absolutely, and it's imperative, therefore, that we fully understand.
Sure, fair enough. And as I say, something to similar effects is reflected in the Brown case. And as I say, without.
All right. Well, we have your submission very clear.
Yeah. Okay. Fine. Great. And that submission, and in a sense, you tie it up with the next point, which is 4. So 4 of this, 26.4. A minister must assess the risk and extent of any adverse. So for minister, read decision maker or whatever. But other than that, must assess the risk and extent of any adverse impact and the ways in which such risk may be eliminated before the adoption of a proposed policy, not merely as a regard action. Obviously, part of that is about you've got to do it at the time, not later. But it's also making a more simple point, which is that you've got to give some substantive consideration to the issue, not to the general need to comply with the duty, not with the fact that in some general way that it's possible there will be some equality implications. you've got to grapple with what the equality implications are. That, with respect, marries up with the point I was seeking to make a moment ago. I don't want to trespass over or grow too much on the on the kind of delegation point, but on the other hand, that's why it's important to think about what the decision maker is told. If the decision maker is told, here's the detailed equality impact analysis, now you can, as it were, satisfy yourself about the equality implications, fine. Because on that basis, he's been given the information which enables him to perform the duty in full. But if the only thing he's told is someone else has satisfied themselves, you don't need to effectively, you don't need to trouble about it, then you won't, the minister, the decision maker, won't have themselves assessed the risk and extent of the adverse impact. They'll just be noting that someone else has done it and is satisfied. And the similar point, I've taken you to 5 and I won't go back to it briefly. I've taken you briefly, but 6 is making a similar point. It's the other side of the coin. General regard to issues of equality is not the same as having specific regard by way of conscious approach to the statutory criteria. And that's, I think, just the flip side of the coin. You've got to deal with the particular issues in the case, not a sort of general hand-waving about how desirable equality is in general.
Yeah.
How does that sit with a series of authorities that make it clear that you don't even have to refer to Section 149 or to its predecessor?
My lady, yes, it sits completely comfortably, my submission.
Right.
Because you don't have to refer to Section 149, and nor does referring to Section 149 save your decision. Again, they're opposite sides of the same coin. If you've in substance complied with the duty, because you have plainly had regard by way of substance to the fact that there are these equality implications and that they have certain implications, it wouldn't, in my submission, my concession, matter that you didn't know anything about Section 149, because you would in substance have had regard to the issues that Section 149 requires you to have regard to. But by the same token, if you've named, I'm so sorry.
Well, I was just going to say, so a lot of the dicta in paragraph 26 are not entirely accurate because they don't reflect the point that emerges from those authorities, some of which are in the House rules and the Supreme Court. But you don't have to refer expressly.
I don't understand them to be at all inconsistent. They're making the same point in my submission, which is it's a duty of substance, not of sort of name-checking the existence of the duty. I don't think, well, respectfully, I mean, I don't know what particular passage my lady has in mind, but I don't see...
For example, at 6, general regard to issues of equality is not the same as having specific regard by way of conscious approach to the statutory criteria.
Yes, my lady. I respectfully, again, repeat, that's making the very point. It's not having regard to the existence of Section 149. It's having regard to the criteria it sets out. Whether you derive them from Section 149 matters not. What you have to do, though, is have regard to the matters which Section 149 requires you to have regard to. So that's another way of putting it. Certainly, that's how I read that. It's about substance, not form, in other words. So that's why having I know Mr. Molson suggests otherwise, but that's how having a section report which says Section 149 requires you to do certain things doesn't save the decision. And Mr. Molson suggests otherwise, nor is it necessary to have it. Now, it's a good idea. It might be a good idea to have it, because if you have it, you're more likely to then comply with it. And there's a picture about that. But again, I can't put it, I think, more clearly in saying it's a duty of substance, not form. What you've got to do is that you, as the decision maker, must grapple with the equality implications, good and bad as they may be, of the case, and put them in the mix. That's how I certainly the submission I make, and that's what I derive. I don't see fracking as inconsistent with that. Quite the contrary, it's what I derive from. At any rate, another way of putting a point, I suppose, is way of dealing with present purposes is that whatever the nuances of that particular debate, I don't think it actually arises in this case, because of course, what it's worth, they undoubtedly did reference section 149. The argument is about whether they comply with it.
Well, I think we get beyond that, don't we? Because it's common ground that not only did they refer to section 149, they adequately and accurately summarised its effect.
Albeit in, let's say, a fairly standard part of the report.
That's common ground.
That's so far as it goes. They do. They set out what they have to do.
Your submission, your central submission, the core submission is that they simply did not grapple with the equality implications.
Yeah, that's
particularly having regard to the implications for those with disabilities.
Correct. Yeah. And I focus on disabilities partly because that's my client's position, and partly because it does seem likely that they're most acute in relation to.
And you submit that looking at the relevant materials as a whole and fairly,
yes,
that must be the conclusion.
I do, and I'm going to come to, without I hope labelling it, come briefly back to that.
But we've captured.
That's the submission. That's
the core
the submission. It's a pretty simple submission.
Submission and the appeal. No, but I mean it's important that we should look at the materials as we have done, and do so now in the light of the relevant jurisprudence.
While we're on Brecking, just two other quick points. I note, I'm not going to read it out and I don't rely on it, but I just want to note it so it's not thought that I'm ignoring it. What 8 effectively said, it quotes Lord Justice Elias in an earlier case early. What 8 says, it makes the point it's a duty of procedure, I suppose is one way of putting it, not outcome, as is often sometimes said. So in other words, as long as you've had regard.
Yeah, that's Lord Justice Baker, Dyson in
and that's another very well-known and often stated principle, and I don't seek to deny it. Of course, my case is not they should have achieved, not, because obviously my client has views about it. My case to you is not they were bound to reach a particular outcome, it's that they didn't actually consider the issue. They failed in the duty to do it. So that's 8. And then finally, sorry, it gets a bit, there's a lot of complicated sub-paragraphs in this paragraph, but it's paragraph 26, 8, Roman 2, so we were towards the bottom of page 88. He simply cites, I think it again is Lord Justice Elias in the Hurley case, talking about the Tameside aspect. This is the duty of inquiry which can arise in relation to the public sector equality duty. In other words, if you don't know the relevant information, you've got a duty to go out and get it. So that's the last aspect that I draw attention to, and I'll come back to you briefly in my submissions. That's Bracking. There are 2 other authorities I want to touch on pretty quickly, I hope. They are Hollow and then briefly the UTAG case, which my lady drew attention to. So Hollow, I do so, it's not a case I rely on, I do so defensively because I think Mr. Mole places considerable reliance upon it. The general proposition he takes from it, which so far as it goes I don't, of course, deny, is that context is very important, and so it can be a pretty fact-sensitive exercise to work out what the duty requires in a particular case. Obviously, I accept that. You have my submission. This is a context where, given the obvious implications for disabled people, actually it should be in front and centre. But having accepted the general proposition, I think it is important just to see, in fact, the context in which those remarks were made, and certainly one doesn't take anything very much from the facts. From the way the court resolved it in the particular case when one sees a different context. So, taking it as quick as I can, we just look at the headnote, tab 5. I'll just read the first half of the headnote. The local authority approved detailed service revenue and capital budget, so it's budget setting, for 2018-19 financial year, in terms which involve significant reductions to its budget for schools and special education needs and disabilities, with identified areas of focus, later abbreviated to AOF, for savings on special education needs, including inclusion, etc. In that regard, the budget identified areas of spending which the local authority could potentially make savings, although at the date of the decision to approve the budget, no specific cuts had in fact been decided upon or worked out. So you've got a pure budget decision which identifies potential savings in a particular area, and those are areas which obviously have equality implications, special education needs and so forth. That's the basic context. And we get a bit more of the context if I can invite the court to turn up 1891 of the report, paragraph 66. As the evidence adduced on behalf of the council shows, the court, I don't want to go 116 in the numbering we've added. As the evidence adduced on behalf of the Council shows, the decision on the challenge was, as the Cabinet was aware, a decision to include for budgetary planning purposes, AOF, that's areas of focus, which, to use Mr Mill's words, were broad areas in which work could be done by the Council to identify ways of reducing the cost of sand and so forth. Importantly, as the Cabinet were also aware, as and when concrete proposals were developed to achieve the identified savings, they would result in any variations to the services actually provided. The proposals would be consulted upon and assessed at the time. So the best analogy, it's not perfect, but you may say this is quite closely analogous to the 2019 decision. It's setting a framework within which certain decisions are taken, but subject to further assessment. And then if we go to see how the court deals with equality impacts, and the passage which I think Mr Mould relies on and has sidelined, it's 79 and through to 80. Well, I think he sidelined 79 to 80, but it's quite important to see 80 and 81 and 82. So 79 sets out the PSED. Paragraph 80, totally accept this as a general proposition. We start by observing what constitutes due regard will depend on the circumstances, particularly the stage that the decision-making process has reached, and then the nature of the duty will vary and so forth. I won't read out every word.
Could you read that out?
Oh, I'm so sorry. Yes, of course. And that the nature of the duty to have due regard is shaped by the function being exercised and not the other way around. I take no issue with that. That is a general proposition. Just picking up on the context, you then read on. Do you want any else particular? 81. The EIA, there was an EIA, for example, described the impact for SEND saving of 10.7 million, etc. The SEND passage which I read unless Mr Mould wants me to insert it, and then
So the EIA said impact to be determined.
exactly that's the point. And so the simple point is this is a context where you've got a budget which doesn't commit to anything, and if you commit to anything, if there's a future decision about committing to anything, you undertake the analysis at that stage, and that's the context in which the court found that was.
So what you're saying, perhaps in other words, is in hollow on the facts, there was an inchoate position.
Inchoate is a perfect word. I wish I'd thought of it.
Whereas here, albeit experimental, the position was not inchoate; it was coate.
Correct. It has legal implications. My client is liable to fines if she crosses the LTNs and so forth. And so is everyone else in Lambeth. Traffic starts piling up on neighbouring roads, all the rest of it. Fundamentally different. And actually, as I've said, closely analogous to an earlier stage, because it's all about, in a sense, stage is important, to an earlier stage of the process we've been looking at, when the Cabinet adopts the transport strategy, etc., in 2019. The detail is to be assessed. It's inchoate in that sense. That's why it's fundamentally different. That's why I've made no criticism. Of course, I can't by reason of time, but I wouldn't make any criticism of the 2019 because it's not doing more than setting out a roadmap for the future. So that's hollow. That's all I'm going to say about it for now, subject to Mr Mould. And then I think I ought to briefly touch on UTAG. I need your attention to. I mean, I don't have a positive submission to make about it.
Right.
So I'll take it quickly. Maybe now. Slave. Here it is. Sorry. Loose. So the court has a copy loose or in the authority number.
Yeah.
I'll take this quickly because I don't say it greatly illuminate. I'm grateful to my lady for drawing attention to it, but I don't think it takes the note very much further forward. This was a challenge, as my Lord Justice Lindblom will know, to two things actually. First of all, a statutory plan and guidance adopted by TfL and the Mayor, and secondly, to a specific, more concrete, as it were, decision, in relation to the, I think it's the A10 in London. It's all about taxis and I think particularly about taxis. But anyway, I'll just very quickly show you what happens in relation to how the court deals with the PSED issues. So so they're dealt with separately on those two topics. In relation to plan and guidance, it's picked up in paragraph 69 onwards. I don't think, if I've understood rightly, there's not as such an EQIA in relation to the plan and the guidance. And the plan or the guidance, I haven't fully distinguished between them. Effectively what they do is advise local authorities taking specific decisions, implementing decisions, to ensure that equality impacts are properly assessed. And you see that in paragraph 70, second paragraph of the quote, I think, which is from the guidance. Officers should ensure that all impacts on protected characteristics will be considered at every stage of the programme. Now, the point that Mr. Jaffe for the Mayor and TfL was able to make, and which the court accepted, is basically it's just the hollow point again. This is inchoate, it's just guidance. All that it's doing is saying that when councils come to implement the detailed schemes, which it undoubtedly is recommending at a general level, at a high level, they properly assess the relevant impacts. And so again, it's inchoate in that sense. It doesn't have any immediate legal implications. That's for assessment in the individual case. See, and I'm taking this quickly, but see paragraph 1771. So again, it's just in that respect, it's just the hollow point. Not, I think, citing hollow, but entirely correctly reflecting the same line of reasoning. Then in relation to the A10, I'll take this, I mean, the discussion begins at paragraph 112, and again, I don't take you to it, but the fact that there was an EQIA is reflected in paragraph 99, and some of the bits of it are quoted, but the discussion in the judgment is from 112 onwards. The very short point is, I mean, I don't understand to establish any general proposition of law. It's a case about whether on the facts the EQIA was sufficient in the context where there was an EQIA, not a draft one, and it was before the decision maker. So it takes us no further forward in my submission. It's a case about particular facts in that respect. Obviously, it's an important case in all sorts of respects. And indeed, the subject matter is important. But in terms of advancing it, where we stand on the law, I don't understand it to take us no further forward. I don't think Mr. Mould makes any particular, he's like to make any particular points about it, but no doubt we can discover, and if necessary, I'll respond. And my lady, that's what I want to say about the law. Hopefully I can draw the threads together relatively quickly now.
Thank you.
My Lord Justice Lindblom correctly captured, I may say so, my key submission, which is simply that having regard to those principles and by reference to the material that I have shown, there was not a sufficient discharge of the duty, there was a due regard. Indeed, on the facts, I don't need to go so far, there was in effect no regard, because there was no attempt by the decision maker to balance, etc., the relevant impacts. Now, I spent quite a bit of time going through the background before we get to the October report, the October decision. But I should say, really just to demonstrate a negative, which is that prior to October 2020, the exercise has not been done. And if it goes too far to say that nothing relevant at all has been done, I think I am entitled to the submission that precious little has been done. There's a recognition of the potential benefits of LTNs as part of a package of wider measures, and a clear recognition, remember both in 2019 and in 15th of May 2020, of the need for further work and assessment. Indeed, the 15th of May decision explicitly envisages that the assessment remains to be done, the equality assessment remains to be done. So you get to the October 2020 report, And one asks the question, I say you ask the question, did this decision maker pay any or sufficient regard to the equality implications of the decision that he was taking with those now immediate legal consequences? And for reasons which, in a sense, are obvious, I say he did it. But if we just, I said I'd just turn it up again briefly. In the supplementary bundle, I think it's tab 11. Yeah, it's tab 11, and it's my page number, remember, is wrong, but it's internal 8, section 7.
It's page 233 in the bundle.
I'm very grateful.
233.
233.
Yes.
I'll try to remember that. Yes. Well, I probably won't take you back to it at no time, but if I do need to, I'll have it written on the bottom of the page. So 7.1, measures expected to be brought forward are principally intended to reduce inequality by doing this. I'm so sorry, I'm in the wrong place. I'm in the wrong place. You may not be. I was in tab 10, I do apologise. It's section 7 of the October report,
yes,
233.
That's right.
I'm very grateful. Please excuse my... So, again, a separate equalities impact assessment has not been completed. True it is. There's a general statement. This is, as I understand it, this is advice to the decision maker prior to the making of the recommendation detailed in this report. So prior to, not for you, and there's no indication the decision maker has been involved in any detailed way before. Regard has been had. So not we're telling you to have regard has been had prior to the decision. By who, we don't know. Presumably people are carrying out EQIAs and so forth. And that's it. And then the protected characteristics are listed, and obviously disability is listed there as one among many. But that doesn't begin to conduct any analysis of the kind needed. And then 7.2, and this brings us to some extent back to this delegation point, but the assistant director, so someone else, has approved the assessment. So if the duty were on the decision maker to be satisfied that someone else has done the exercise, it could be said that that would be sufficient. But in my respectful submission, that's not the duty. The decision maker, the person charged with the responsibility for the decision, the person who has in a sense to answer for it, I suppose, must themselves consider the relevant matters, balance the relevant impacts. Not merely satisfy themselves that someone else who is not charged with that responsibility has done so and been satisfied about it. And that's the effect of the paragraph. Now, there is another curiosity, which is that I don't quite understand the basis, I don't say necessarily it's untrue, but I don't quite understand the basis upon which the assertion is made that the assistant director has approved, because we know that in fact most of the relevant EQIAs are in draft and haven't, I assume that the relevant analysis is what's in an inchoate way developing in those EQIAs. But they haven't yet been, with the possible exception of Roughton, they haven't been signed off yet, even by the team leader, let alone by the person who, if you remember the way the front page of the decision works, the person who's given responsibility for making the decision, a fortiori, not by Mr. Disumley. But at any rate, whatever the status of that assertion, it's not been explained, it's not been justified in evidence, we've been given no context for it, nothing. Plainly, Mr. Disumley is not being given the material to himself carry out the analysis. And in my submission, I respectfully say one couldn't have a clearer case of a failure to discharge a statutory duty, the duty which Parliament, let's not forget, has regarded as key.
So sorry, I just want to understand your
Yes,
submission, Mr. Bewley. You say Mr. Solly was not given the material to himself carry out the analysis. So what would that entail? Would that entail him reading the EIAs, or doing the underlying work? I mean,
Oh, it means, well, it means, what it means, maybe, he doesn't have to do the underlying work in the sense of doing the research. Depends.
Right.
So I don't say that he had to go off and do, absolutely not. It's perfectly proper for him to be informed by advice by other officials, by them giving him the primary material, or a summary even of the primary material upon which to make his decision. That's fine. And he's entitled to take, not in the end their analysis, but he's entitled to take their evidence at least as read and say, well, he's not required to say, oh, I need to satisfy myself, I need to go out and knock on doors and go to, it's not entitled to take it as an evidential basis. And he's entitled to adopt their analysis. I think it probably isn't quite enough for him to just read the reports, but if he reads them and is able to say, I've taken this on board and I accept it, then that may be enough.
So I hope I'm not cutting across my lady's question. If I am, I hope she'll forgive me.
no, not at all.
If he had adopted the assistant director's exercise,
Well, I mean, he's got to acquaint himself with it. So he can't just say,
having acquainted himself with
sure.
it, yes. If having acquainted himself with the assistant director's exercise, he had adopted it
yes,
unequivocally,
yes.
That could be enough to
Yes.
discharge the
Yes,
due
absolutely.
regard duty.
Yes. So just as a minister, even one who's got, there are occasional, for example, ministerial decisions where the minister themselves have to take a decision. Generally, Carltona applies, but there are exceptions. But at any rate, and even if Carltona applies, if the minister purports to take a decision, he's got to take the decision, as it were. But of course, a minister is entitled to act on advice. Of course, to take a different context, of course, a judge is entitled to accept evidence. He doesn't have to go out and view the scene himself, and so on and so on. He's entitled to adopt an expert analysis, and so on and so on. But he or she does need to grapple with it, and to grapple with the issues, to satisfy himself that the analysis of benefits and disadvantages is one that he should adopt. And in doing so, for example, to think about, well, actually, they've made this point, just to give a bit of context example, to say, well, actually, they've made this point, I'm not saying required to do this, but they've made this point about reliance of certain people on motor cars. Perhaps, even though they haven't suggested it, perhaps we should think about an exemption or a dispensation, that sort of thing. Mr. Tisonmu has not been placed, or is not in a position to do any of that, because he's just told that someone else has done it. And in my submission, it shouldn't require Bracking to establish that that's not good enough, any more than it would be good enough in relation to any other material consideration. He's the decision maker. He's got to take the decision, having regard to balancing out the relevant matters. And by the way, balancing out of the relevant matters doesn't just mean balancing out within the balancing out within the EQ. It also means putting them in the balance against the other relevant matters that you're required to have regard to under section 122 and so forth. To make equality impact an integral, to make the statutory criteria an integral part of the decision-making process requires you to put them in the frame against other relevant matters and to reach a conclusion. And that's why, quite apart from Bracking, that means you've obviously got to understand what they are. Mr. Tisonmu doesn't. Got no basis to do so. So, does the perceived advantage or hoped for advantage in relation to traffic levels generally justify the rather draconian impacts on this group or that sort of thing? No way Mr. Tisonmu could do that, because he doesn't actually have any sense of what those issues are or how they've already been balanced out within the report.
So do you say...
Or whether he might reach a different conclusion. I'm so sorry, Ronald.
No, sorry. I was going to ask you, do you contend then that in the end he had no regard to the matters he ought to have had regard to?
In effect, yeah. I mean, he didn't... Yeah. I mean, he did have no regard, that's right. But at any rate, I mean, frankly, yes. But of course, I don't need to go quite that.
No.
But I mean, on the face of it, he had no regard. He had regard. He was aware of the desirability of the meeting the statutory duty, so far as one can see. But he didn't, sorry, I should have said meeting, not the desirability, that's one of the common errors. It's not the desirability of meeting the statutory duty, it's the desirability of meeting the aims to which the statute points.
Yes. Yes, but
It's not even that, it's having due regard to the need.
Yeah, sorry, yes, that's right. I'm not seeking to say otherwise, but I was just trying to correct
what has to be had regard to is as defined in the statutory provision.
Yeah, well, I showed you earlier,
Yes.
perhaps we should just turn it up briefly, but in particular, probably most pertinently to this case, so it's 3A, subsection 3A, which is expanding on 1B, if you recall.
Yeah.
So 3A, removing or minimising disadvantages, and I say implicitly, not increasing them. So the effect of this decision was, certainly on my client's evidence, on the evidence of the DFT report, to actually or potentially create significant disadvantages for disabled people.
While at the same time removing other disadvantages.
Well, possibly.
Some
I
other-
mean, I don't know.
Another cohort of disabled.
Possibly. But at any rate, possibly. But I suspect my client wouldn't actually agree with that. But I mean, that's in a sense by the by. Because the analysis wasn't undertaken, certainly by the decision maker. We don't know, and no court's not undertaken. There are obviously swings and roundabouts. Point is, you've got to make yourself aware of the swings and roundabouts in equality terms, and then put them into the general mix. Mr. DeSomry doesn't do that, and he can't do it. There's no way he can do it in the information that's been given. I do respectfully say, it's just standing back from all that, it's pretty extraordinary in the context of this kind of case, where on the face of it, my Lord Justice Mills said, well, isn't it obvious that there will be certain effects? None of that is reflected upon as a relevant matter to put against the decision, to think about, etc. It's just not there. Complete absence of that kind of analysis. Now, I'm conscious of time. In my skeleton argument,
Yes.
and perhaps I'll just do it with giving you the references rather than going through it. I thought I would.
Well, as you wish, yes.
I picked up, I think this is probably sufficient because actually I've probably made the key point. I pick up on paragraphs 156 and 157 of the judgment, which I set out, read them in their full way.
Where are you in the skeleton now?
So I'm paragraph, 47,
Yeah.
into 12 of the skeleton, page 12 of the skeleton, page 27 of the core bundle. So I pick up in particular on those paragraphs because I understand them to be the judge's analysis of the effect of the paragraphs we've just been looking at in the October report. And then I seek to, as it were, pull out of them, paragraph 48 of the skeleton, what you get out of them. So in my submission, the judge's own the point is in a sense, on the judge's own findings about what Mr. DeSomry is doing in paragraph 7.1 to 7.3, is not actually undertaking any substantive consideration. And I say that's the judge's findings and my characterisation of the judge's findings is a fair reflection of 7.1.7 to 7.3. And it's the same point, that there's nothing. But in a sense that may not matter because you're, deciding this case, it's an issue of law, you're deciding the case on the papers, not bound by the judge's findings of fact or anything in any event. But if I need to, I point to the judge's finding and say, well, it's all, even on the judge's own analysis, looked at in accordance with the proper principles, you get to the same result. And the judge is simply wrong to say, to accept Mr. Moll's beguiling submission. This is all fine because it's just experimental. You've seen the context of an experimental order. They can last for up to 18 months. They have so far lasted for getting on for 18 months in two of the cases and over a year. Well, around about a year or slightly over a year in one of the other ones. So Railton was made in January 21. And of course, and the others were made in the autumn of 20. But of course, in two of the cases, it goes back further than that because they're continuing temporary orders that are already in place. Sure, they're experimental. Sure, that's part of the context. It is part of the context. But it doesn't change the fact that these are very substantial decisions with very significant legal consequences, exposure to fines and so forth, and practical consequences for someone like my client and many others in her position. And in those circumstances, to adopt an approach which I think Mr. Mole would invite you to adopt, saying, well, actually the experimental context makes all the difference and legitimises an approach of not doing the exercise but waiting for the experiment to resolve itself, is just not consistent with the statutory requirements.
Compliance, did you say?
I think I said not consistent with the statutory requirements.
Requirements, yes, sorry.
It amounts to non-compliance.
Yeah, sorry, I misheard you.
Yeah.
Right.
The judge there's a discussion in the judgment about this concept of rolling review. So, in my submission, it's a bit of a red herring. It's the last point, and I'll just sit down. In my submission, it's a bit of a red herring. I don't dispute that one of the things you get from bracking is the duty is a continuing one. Obviously, if you're conducting an experiment like this, having taken the decision, you continue to monitor. That's unexceptionable and desirable. And in that sense, rolling review is a jolly good thing, and indeed it may be a statutory requirement. But the fact that you may do that is not an excuse for not doing what the statute requires at the time you make the initial decision. If you've done that exercise and said consciously, look, there are some things we're still not sure about, we can't get to the bottom of, we still think it's desirable to do the experiment and all so forth, different matter, but that's not this case.
Well, if your submission is correct that no regard was had,
The context doesn't help.
then the context makes
yeah,
no
that's
difference.
right. Yes, but even that must be right. But even if I sort of slightly over-egging the pudding and some sort of regard was had, I mean, what you have to have is sufficient regard, due regard.
Well, the other submission
And the context
will be that due regard was not had even in the experimental context.
Yes, that's right. The experimental context is undoubtedly relevant. Indeed, it might be quite important. I'm not suggesting otherwise. But it doesn't save a decision like this, where the statutory criteria, not in any substantive, proper way, put into the mix at the time of the initial decision. My lords, my lady, those are my submissions. There's an issue about relief. I'm conscious of time. It occurs to me, I think Mr. Mould may want to park that in any event. We'll see reasons, but I'm inclined to sit down now unless you want me to.
Yes, no, I think, subject to my lord and my lady, that we can leave that for now, in any event, and come back to it as needs be in due course.
Okay.
Those
are my submissions. Okay.
Thank you very much, Mr. Bewley. Thank you. Yes, Mr. Mould.
My lord, my lady, the starting point of my submission is to recognise that the issue in this case really resolves down to the adequacy of the delegated directors' consideration of the questions raised by Section 149 of the Equality Act. In the light of the information given to him and the advice provided to him for consideration in the October report, it's clear that that report was intended to be a comprehensive piece of advice and to provide him with the information that he needed as delegate to make the decision asked of him, that is to say, whether to proceed with the low traffic neighbourhood experiment and to authorise the making of the orders needed in order to give legal effect to that experiment. And therefore it's right that the court, in judging the strength or otherwise of my learned friend's criticism of the legality of the decision made by the director under section 149 of the 2010 Act, should focus its inquiry and its analysis upon the contents of that report as the primary source of information. Now, of course, there is other contextual information that is relevant, but that information is itself noted to a greater or lesser degree of particularity in the paragraphs of the October report as well. For example, the guidance given by the Secretary of State in May as to the need to take the opportunity to improve traffic highway safety and environmental considerations in the light of the COVID-19 pandemic and the great reduction in vehicular traffic on the roads during the early period of that pandemic as it affected this country. So there is a good deal of consonance between Mr. Bewley's approach and my own in that sense. He says you should focus on the October report. I respectfully agree with that, and indeed that was essentially the approach taken by the judge in the reasoning that he gave for rejecting this ground of challenge to the director's decision. And so the issue is really whether the director's consideration of equality impacts and the possible need for adjustment in order to reflect differential effects, disproportionate effects arising from the proposed experimental orders was sufficient to discharge his duty under Section 149 of the 2010 Act or not. He was presented with two specific pieces of advice on that. Firstly, he was reminded of the basic constituents of the duty in paragraphs 4.16 and 4.17 of the report, in terms that, as I understand Mr. Bewley's submissions, he does not, Mr. Bewley accepts were sufficiently accurately expressed as to give rise in themselves to no quarrel. And secondly, he was given advice and information as to the which was designed to enable him to discharge that duty in the circumstances of the decision that he was being called upon to make. And that, of course, is those are the paragraphs, the three paragraphs in section 7 of the report, which you have at page 233 of the supplementary bundle. It's my short submission that set in the legal and factual context in which the decision that he was called upon to make, he made. That advice and that information, proceeding on the reasonable assumption that he accepted it without qualification, was sufficient to constitute the discharge of his duty, sufficient, in other words, to constitute due regard to the statutory considerations that are laid out in section 149 of the Act. I say on the reasonable assumption that he considered and accepted that advice without qualification. It is, I think, not suggested by Mr. Bewley that that assumption is unreasonable or unwarranted. And certainly it would chime with the established approach that this court takes, indeed the authorities should be taken in relation to broadly cognate contexts such as planning decision-making, where it is unnecessary for a planning committee to set out extensively in its minutes the advice that it has received and the recommendations that it has received from a planning officer in relation to a planning application. It is sufficient that the minutes record that it accepted the recommendation and accordingly resolved to accede to the decision recommended by the planning officer. In my submission, there's no obvious reason why this court shouldn't adopt the same approach in this field.
There's authority in the planning sphere gathered in Mansell,
Indeed so, yes.
which is familiar, I think. Yeah.
Yeah.
There's a judgment of Lord Justice Lewison's as well, which explicitly says what you've just submitted.
Well, that is, I hope, without resorting specifically to showing you authority, that's sufficient to draw that parallel. And, as I say, I don't understand Mr. Bewley.
No, I, on the contrary, would understand Mr. Bewley to have positively asserted that
Indeed,
one
right.
gets the reasons from the delegated report.
Indeed so.
So I think that's common ground.
So there are essentially two questions, as I understand it. The first is against that background. The first is, does that evidence demonstrate, as Mr. Bewley would have it, that the director had no regard, or perhaps no meaningful regard, to the statutory considerations arising under Section 149? And the second question is, if the answer to the first question is, well, he had some meaningful regard, was the regard that he had on the evidence of the report, was that sufficient to discharge the duty to have due regard, which is the legal requirement which is based upon him? Now, as regards the first of those questions, in my submission, that is relatively straightforwardly answered by the simple presence of the guidance given in paragraphs 416 and 417 of the report, and the information and the advice that is provided to him in paragraphs 7.1 to 7.3. In my submission, it cannot, with respect, sensibly be concluded that in the light of those passages, he had no or no meaningful regard to the statutory equalities considerations. The proper question in this case, question addressed by the judge below and in my respectful submission to be considered by this court, is whether the regard that he had was sufficient to amount to due regard in the circumstances of the decision that he had to make. So far as there is any guidance from the authorities, in my skeleton argument, I have referred the court to the recent decision of this court, sitting, I think, as the court of first instance in the violence against women case, which is in the authorities bundle at tab 6. My lady will recall that case. She was one of those within the constitution of the court, the Lord Chief Justice, Lord Justice Holroyd and my lady. And the facts, of course, as is often the case in this field of litigation, very different to the facts of the present case. But there is, I would respectfully submit, some helpful guidance at paragraphs 85 and 86 of the judgment on page 148 of the authorities bundle, which comments, amongst other things, upon the approach that should be taken to paragraph 26 of the judgment of Lord Justice Batum in the Bracking case. Shall I just pause for a moment whilst the court reads?
Yes, thank you.
85 and 86.
Yes.
Lord, it's my submission that that brief statement of approach, if you will, in a relatively recent decision of this court, as a matter of principle, is all that this court needs to consider and to take into account in reaching a conclusion on the due regard question in the present case. That said, I am not seeking to amount any degree of attack on the correctness of the proposition stated in more detail by Lord Justice McComb in the Bracking case. Mr. Bewley repeatedly said that I hadn't quarrelled with what he had said about that, and he's right. But what I do is to make the broader base submission that the salutary warning given by this court in paragraph 85 of the Violence Against Women case is one that this court ought respectfully to have in mind. And here, the question is, it can be stated in relatively straightforward terms. Notwithstanding the relative brevity of the information and the analysis of equality's impacts that is set out in section 7 of the October report, was that analysis nevertheless sufficient, accepted as it was by the director, to discharge his duty? And as regards that point, there were essentially two principal points of factual and legal context. So far as legal context is concerned, the critical point is that the decision he was being asked to make, and therefore the effects of which he was being asked to have due regard to, was a decision to introduce an experiment. And the experiment, or the trial run, if you will, was to make traffic management interventions in defined areas of the borough with a view to discouraging through traffic from travelling through identified local community areas and rerouting that traffic onto designated through routes. In other words, its avowed purpose and intention was to displace through traffic and to, if you like, to encourage, I might even say to force it onto designated through routes. Part of that intention, or key to that intention, was to improve the environment, the highway environment, and the broader environment for the community living and working within those low traffic neighbourhoods themselves. And that improvement was seen in part to be a factor that would benefit persons with protected characteristics, whether it be by reference to age or disability or whatever. But the corollary, or a corollary to that intention, to that benefit, and to that intention, was that the displacement of volumes of traffic from passing through the areas onto through routes might have unintended effects in terms of lengthening journeys, not only for the general public and for local citizens, but for members of groups with protected characteristics. Now, paragraph 7.1, 7.2 advised the director that there had been some consideration of the question whether the experiment, if implemented, would give rise to, as it was put, disproportionate effects on groups with protected characteristics. And the provisional judgment had been that it would not. But the veracity, to use the word used, of that provisional judgment required to be explored further during the course of the experiment. And that exploration of that judgment would be informed by consultation and engagement with the local community during the currency of the experiment. That is the burden of the advice given in paragraph 7.2 of the report, page 233. So the legal context was that the very thing that the director was being asked to consider and to approve, the intervention that he was being asked to authorise, was recognised as potentially having disproportionate effects on persons of protected characteristics. A provisional judgment had been made that it was not going to do so, but that was a question that remained at large and needed to be addressed during the course of the experiment. My submission, that is that analysed in those terms, which in no way departs from the substance of what is said in paragraph 7, in section 7. That was a legitimate analysis for officers writing this report to have put forward, and a legitimate analysis for the director to have accepted in fulfilment of his duty to have due regard to the potential impacts of this initiative on persons with protected characteristics, including the cohort and subcohorts of those with disabilities, such as, in the case of Ms. Sheakh, persons who are reliant on the car to be able to make their journeys and to socialise.
Is it a fair understanding of the report as a whole, including what is said in section 7, that the advice was that there would inevitably be, or there would be a high likelihood of adverse impacts on, at any rate, some of those with protected characteristics? The report talks about increased journey times and increased traffic on other roads. The question was whether, looked at in the round, those were proportionate to the benefits to be achieved, and it was that which needed to be investigated.
My Lord, yes. In fact, I would respectfully accept that proposition. There is a further related point that is evident in the report read as a whole, and that is not only was the question of whether the impacts on persons with protected characteristics across the range of those statutory cohorts, whether they would be in proportion or disproportionate to the benefits, but also whether the impacts on those persons, the degree of difference that would be experienced within different cohorts of persons with protected characteristics. In other words, the report recognised that there was a need to explore that, but the level of granularity with which that exploration needed to be carried out, and which implicitly was required in order to reach a conclusive rather than the provisional judgment, would be informed by the progress of the experiment and by the process of consultation and engagement with local communities that would be part of the experiment. So, in a sense, well, not in a sense, it boils down to this. What the director was being asked to do was to make a choice. Either to accept the approach which was recommended to him, which was that there should be an experiment, and that the effects, differential or disproportionate or otherwise, on persons of protected characteristics should be better understood, and any necessary or appropriate adjustments made in the light of that understanding through the operation of the experiment. That was the first option. Or, as was clearly open to him, that he should reject that recommendation in favour of the approach that the council had, prior to the pandemic, indicated it proposed to take in relation to low traffic neighbourhoods, which was to engage in that process of consultation, engagement and information gathering before making the orders themselves. In other words, to proceed in the ordinary way with a view to making orders under Regulation 6. And the court will recall the passages in the Transport Strategy Information Plan where the council made clear in 2019 that it intended to approach the matter in that more measured fashion. Can I just remind you of the reference for your note? It's at pages 170, 168 and 173.
You want us to look at those?
Just so that you have the evidential basis for my submission in mind, if I may. Yeah. So, if you remember, the Transport Strategy Implementation Plan itself began at 163.
Yeah.
At page 168, there's a subheading 10, working with the community to deliver change.
Yeah.
And the second paragraph said that engagement with the local community on the development of the transport strategy is a starting point. The projects and programs we will now deliver as a result have community engagement at their heart. Key programs, such as healthy routes and low traffic neighbourhoods, can only proceed with the support of local people, and we set out our approach to engagement in the relevant appendices to this document. So, at the time of promulgating the strategy in late 2019, the inference is clear. So far as interventions such as low traffic neighbourhoods were concerned, the intention was to engage the community as part of the process of preparing the ground for those interventions, and only to make the orders in the ordinary run of things once that process of engagement had been carried out. No doubt, in order to inform the shape of those schemes and to enable a more granular understanding to be obtained of the impacts that they may have not only on the community as a whole, but also of distinct cohorts of persons within the community, such as those with protected characteristics under the Equality Act. The second reference is in this implementation plan relates specifically to low traffic neighbourhoods, which, as you recall, begins at page 169, and it's at page 173 under the heading of timescales, which referred to the first tranche of LTNs, some initial assessment work having begun.
Sorry, I beg your pardon.
173.
173. Sorry.
You should have a subheading timescales.
Yeah.
And this is the final page before the plan, the final page of Appendix B of the Transport Strategy Implementation Plan, which deals specifically with low traffic neighbourhoods. You can see that it's all of a piece with the earlier passage in relation to engaging with the local community in order to obtain information in advance of completing the process of implementation of those orders. So in my submission, that is another important part of the context. The choice that was before the director, had he been asked to make it in 2019, it's very likely that the recommendation would have been to proceed under Section 6 rather than under Section 9. And in any event, he would no doubt have required some persuasion in the circumstances as they were in 2019, that he should do otherwise than to proceed under Section 6. And the critical point there, as you saw from the regulations which Mr. Bewley showed you earlier, the 1996 regulations, is that the process of public consultation and engagement in the case of an ordinary Section 6 order takes place before the order comes into effect. So it shapes the order and the response and the judgment of the impact of it. Whereas under the experimental order, the process of public consultation engagement, the information gathering that will result from that, including any differential effects that it may have, that comes under the statutory scheme. That comes whilst the experiment is in train. So it comes after the experiment begins and the experimental order has come into effect. Now, why was it? And this is the next the further key aspect of the factual matrix. Why was it that in October 2020 we moved from the Council's intentions as stated in 2019, just showed you the two passages, to a recommendation that these initial LTNs should be brought into effect on an experimental basis? And the answer is perfectly straightforward. It was in order to react to and to respond to the guidance of the Secretary of State given in May 2020 that it was essential that London and other traffic authorities should move speedily to grasp the opportunity presented by the pandemic, and that is made absolutely clear by the October report itself at paragraph 2.3 on page 221 of the supplementary bundle.
Do you want us to look at that again?
Paragraph, page 221,
Yeah.
paragraph 2.3.
Yeah. Yes.
You can see the point is addressed head on. Here is the choice being presented to the Director. The speed of delivery demanded by the Secretary of State's guidance is incompatible with the time frame required to collaboratively develop and agree a traffic management scheme with road users, members of the community and other stakeholders. Accordingly, officers consider that introducing such interventions by means of an experimental traffic order is the most appropriate legislative mechanism. And essential to that judgment is that we should, that means not only that we may, but that we must monitor, gather information, monitor and adjust the schemes, the experimental schemes, during the experimental period in order to fulfill the objectives of Section 149 of the Equality Act. Now, there had been some discussion, consideration of the potential impact of the experimental measures. One sees that recorded at 2.2. The choice of schemes had been reviewed by ward councillors and emergency services to establish that any operational or social issues forecast to arise are not disproportionate to the scheme objectives described in paragraph 1.2. Some localised adjustments have been made in relation to each of the schemes. So, for example, in relation to the Oval Triangle scheme, if you look at over the page, at page 222, one can see that some refinements were made in relation to accesses to primary schools and businesses, to reduce the degree of travel disruption to residents of certain estates, and to suppress traffic levels on certain roads. You see that at 2.10 to 2.12. Likewise, in relation to Railton, there's a reference to some localised adjustments at 2.17 to 2.18 on page 223. And so and likewise with St Matthew's, which was then a separate scheme at page 225, paragraph 2.27. So there had been some, there'd been the opportunity to respond to a limited degree to what had been, to what was known from the local community engagement that had taken place. But nevertheless, a clear recognition in section 5 and section 6 on page 232 that there remained clear uncertainties, and in particular paragraph 5.1, uncertainty as to the impact of displacement and driver behaviour through being required through in other words those hitherto using these routes as through routes being denied that choice, being displaced onto other routes, and the impact that might have. 5.2 showed that clearly that a core part of the experiment was to understand and to evaluate the evidence derived from the experiment in order to understand and to reduce that area of uncertainty. Now that goes directly to the point that Ms. Sheakh raises in her complaint, because it is the fact of, it is the risk and uncertainty of the extent of driver displacement, the degree to which that inhibits her use of those routes, because under the experiment she was not granted any particular exemption or dispensation. So she was forced to find her way through with all the other drivers displaced onto those through routes. And she says, there ought to have been a recognition of the impact that would have on me, and appropriate adjustments and arrangements should have been made at the outset. And that's essentially her core complaint. It was open to and ought to have been recognised. In a sense, that's what this case comes down to, because that was left over by the report writer and the director to the experiment. The veracity of whether there was indeed a disproportionate impact would be, for Ms. Sheakh and others like her, was clearly what was in mind in paragraph 7.2. She says it.
Yeah, go on. Yes, sorry.
She says that wasn't. She says that was insufficient to amount to due regard. And my submission is, or not so. But in the circumstances that I have outlined, which were the circumstances essentially that the judge found on, that while she may violently disagree with it, and I understand why, that amounted to due regard in the legal and factual circumstances in which Mr. Desunnu made his decision. I'm sorry about that.
No, I'm sorry to cut in. What I was going to ask you really flows from what you've just said. And maybe you've done this in the skeleton argument, I'm not sure that you have. In the circumstances, how would you characterise the nature of the due regard duty in the circumstances here?
It was to recognise that the reported provisional view of his colleagues, that there were unlikely to be disproportionate effects on persons of protected characteristics.
No, I'm sorry. I think I may have not put the question clearly.
Forgive me.
I'm not asking what the outcome
Yes.
should be characterised as. I'm asking what the nature of the duty was to have due regard in the present circumstances. What was the nature of the duty itself, is what I was asking.
the nature of the duty was to recognise that the limited assessment which was reported required possibly considerable further work, but that process of further information gathering and assessment was precisely within the scope and purpose of the experimental traffic order regime itself. That was what the experiment was designed, both legally, fell within the contemplation of a Section 9 order, and factually in this case was an identified principal purpose of the experiment. See the final sentence of paragraph 7.2. I hope that is the point your lordship is.
Well, I think that is a response to it. Yes, thank you.
I mean, in jurisprudential terms, the duty is not is one which as I understand the summary of the position in the Women Against Violence case, in the paragraphs I've referred to, the duty is one that is if you will, protean in its application. The concept of due regard is not one that lends itself to a clear-cut definition.
No.
It responds to the decision that the person upon whom the duty falls is required to respond to the legal and factual context in which the duty arises in their case. And that, in my submission, is the insight of the divisional court in the Hollow case, to which Mr. Bewley took you, and it was that passage, if you remember, that sentence, where the divisional court at paragraph 80 said, the nature of the duty to have due regard is shaped by the function being exercised, and not the other way round.
So paragraph?
It's paragraph 80 in Hollow, page 118 of the authorities.
No,
that's why I wanted Mr. Bewley to read that out, because it's in my respect, it's an important insight, and I hope goes to the question your lordship put to me.
Thank you.
So what may or may not suffice in case A will often, perhaps even generally, be of little assistance to the court in judging whether on the evidence what was done in case B itself constituted, in legal terms, the discharge of the duty to have due regard. But as I say, the key factors in this case are that in the choice presented to the director was a very different choice to the one that would have been presented in 2019, and the key distinction was the supervening urgency of the pandemic and of the guidance given by the Secretary of State, and it was that tipped the balance between proceeding under the ordinary Section 6 route and the experimental route. But there was an express acknowledgement that if the council, in the case of these 3 low traffic neighbourhoods, was going to proceed by means of the experimental route, it was necessary, in order to fulfil the obligation under Section 149, to place information gathering, better understanding, and consideration of any reasonable adjustments to address disproportionate differential effects, for that to be at the heart of the experiment, and to be at the heart of the process of public consultation and engagement that Regulation 22 of the 1996 regulations required. And that is essentially an encapsulation of the advice given in paragraph 7.2 of the the report.
You say it would be necessary to fulfil the duties that this work be done in the future and during the experiment, but presumably the duty has to be complied with at the time of the October decision. It's
Yes.
either a lawful or an unlawful decision, and therefore what you're really saying, I suppose, well, you tell me if it is or not, is that there was a recognition that before making any decision about whether these LTNs should become permanent, this work would have to have been done during the experimental period.
Yes.
Is
Yes. Yes.
is that a right way of looking at it?
It is. It is. My lord is, in my submission, absolutely correct to say that the decision of the director in October was either unlawful or it wasn't, so far as the discharge of his duty under Section 149 is concerned. He wasn't, as he himself was advised in Section 4, he wasn't. One option that wasn't open to him was to defer the performance of that duty. He had to come to a view. He was presented with the information and advice in paragraphs 7.1 to 7.3 to enable him to consider the discharge of his duty. It might have been open to, it was open to him to have said, I lack the information I need in order to be able to come to that view. Plainly, he didn't take that. He didn't take that course. He was plainly satisfied that he did have the information and the advice that he needed in order to fulfill his duty. He purported to discharge his duty, and in my so I am therefore driven to submit that he did so. But I say that the court can be satisfied that he did so, notwithstanding his recognition that there was more would need to be done in the future in order to continue to develop the scheme and to reflect on its impacts on persons of protected characteristics.
So would you say then that the lawfulness of the decision in October 2020 would not depend upon whether the necessary monitoring, etc., would in fact be done subsequently? It would be sufficient that the decision was taken on a, I suppose, good faith basis that work would be done. Although obviously if it wasn't done, that would impact on any future decision.
Yes, there is no doubt in my submission, no reason to doubt that in deciding as he did, in the light of what he was told in Section 7 of the report, the director clearly anticipated that further monitoring would take place and anticipated the potential for further adjustments to be required to one or more or all of these schemes in the light of that monitoring. That is necessarily implicit in the sentence. The veracity of this conclusion will be explored as part of the 6-month post-implementation consultation period.
Yes, and there is a timetable for all that in Section 10.
Yes.
Is this close to submitting that the true analysis here would be that the experiment was essential to the performance of the Section 149 duty itself? That there was a mutually informing process going on. That's to say that there was you submit that there was a sufficient performance of the due regard duty at the outset, i.e. in October 2020, against the background that went before, but that the experiment itself would inform the Section 149's performance as the results of the experiment emerged. Is that really what you're saying?
Yes, but I'm not. But I don't want to be misunderstood in saying yes. I'm not. I am. I hope I'm clearly making the submission that the director is to be judged to have made a decision.
Yes, yes.
And purportedly, at least, to have fulfilled his duty under Section 149 when he made that decision.
Yes.
It is my submission that on a fair reading of the report and his acceptance of it, he was not simply deferring consideration.
No, I didn't put it like that.
No. But my lord, it's important that I emphasise that, because that is a key part of Mr. Bewley's complaint.
Yeah. Well, the submission is closer then to saying, given the experimental nature of the decision, the actual performance of the Section 149 duty was sufficient and lawful in October 2020, and that going forward, that duty would be performed in the light of and reinforced by the experiment itself.
My lord, yes.
Is that correct?
Yes. That is it, and that was clearly in the contemplation of the director in the light of the advice that he received in paragraph 7.2, and indeed the advice that he received in paragraph 5 in relation to consultation, and indeed in the risk management table on page 233, because the principal identified risk and mitigation exercise that was there stated had to do with the impacts of displacement and the potential effects of that.
Right.
There's both a quantitative and a qualitative aspect to that exercise, as you will appreciate. On the one hand, it's possible through traffic counting and modelling to, on a quantitative basis, to measure the performance and impact of the restrictions. But then there's a qualitative aspect, which is much closer to the issues that Ms. Sheakh raises in her case, because plainly, the more one descends to the detail of impact on particular small groups of people or people with particular characteristics, a qualitative element of analysis and information gathering will become more and more important. One isn't going to discover the degree to which, in regard to her particular disabilities, Ms. Sheakh will or will not be differentially and disproportionately disadvantaged by restrictions on these roads, simply by recourse to traffic. That won't tell you the answer to that. So that's and that quantitative and qualitative aspect, those two complementary aspects, you find reflected in the drafting quality impact assessment reports that you have in the papers in front of you. Just to give you a ready example of that, take the Railton draft report, which is begins at page 237. This is the first version, which I think was in existence from August. At page 262 and 263, you see there's a subheading 2/3 of the way down the page. How do you plan to address and mitigate any negative impacts of the proposal? And we see that the preamble speaks, amongst other things, of potential negative impacts on some people with disabilities who may be affected by longer journey times or altered routes. And there's a reference to ongoing monitoring. The first of the paragraphs under the heading "How we will monitor" speaks to a quantitative approach. It's concerned with monitoring through traffic counting and establishing and appraising traffic flows. The second, qualitative aspect is spoken to in the full paragraph at the top of page 263. We will also be collecting qualitative data How? Through regularly talking to residents and business owners to gather information on the impact of the scheme, online engagement, and that will, says the writers of this document, that will involve seeking equalities monitoring information to allow us to understand commonalities and differences between different equalities groups. This will be used to assess the impact of the interventions against the policy aims and put in place improvements where necessary. So, from August onwards, a recognition that there was this distinct qualitative and quantitative aspect to praising the performance of the experiment and of these experiment LTNs, which would, and it would be the qualitative aspect in particular that would be material to a better understanding of any potential disproportionate and differential impacts on persons with protected characteristics. So the link between the experiment, as your Lordship puts to me, notwithstanding a clear decision by the Director in October, which I say fulfilled was made in fulfilment of the due regard obligation. Entirely consistent with that, a recognition that further work would need to be carried out, precisely informed by the process of the experiment, leading ultimately to decisions about adjustments, no doubt at the time when the decision was made, if it was, to proceed to institute these, to make these low traffic neighbourhoods permanent.
The date of this document, is that August 2020?
Yes, this is the document that the judge mentions in his judgment at paragraph 50. He deals with it briefly in paragraphs 50 to 52 in the judgment.
Right. Are you going to deal with the submission that the Director didn't actually do what he had to do himself?
Yes. My submission is that he did, essentially for the reasons that I've given to the court, because he was provided with information, he was provided with advice, and he made his assessment in the light of that information and that advice. The distinction between this case and the case that is mentioned in the Bratton decision is precisely that. I think that everybody recalls the facts of remember the name of the Kerr and case. No, that's not the right one. It's the Association of Health Schools case. I think the recollection is that as what is said by Lord Justice McComb, page 88 of the Authorities Bundle, indicates that the distinction, the factual distinction in that case was between civil servants acting on what they knew and the minister acting without any knowledge of what they knew and without what they knew having been placed before him. That's not this case. In this case, the director was provided with information and was provided with advice in the light of that information. What I don't say, of course, is that there's any evidence that he went behind what he was told in paragraphs 7.1 to 7.3, or indeed behind what he was told in the October report as a whole. I'm not asking the court to infer that he went away, looked up the file, and read supporting documentation. I am setting out my stall on the basis of the report itself. And whilst the information and the advice that he had was relatively briefly expressed in my submission for the reasons I've given in the context, it was sufficient to enable him to fulfil his duty under section 149. Insofar as there's a record of background information being before him, it's at page 235, which draws attention to the Transport Strategy Implementation Plan, the statutory guidance, street space plan, and the cabinet decision in November in relation to the transport strategy. So, if you will, he took the advice that he received from his colleagues, in particular the process of assessment that was reported to him in paragraph 7.2, including the involvement of the assistant director. He took that advice at face value. That's the only reasonable inference to draw. And I must make my case on that basis. But I don't shrink from doing so, as I say that was enough for the reasons that in the light of the submissions that I put to the court.
Yeah.
Well, I'm conscious of the time, and my own feeling is that I have addressed, I've made the oral submissions that I wish to make to the court in response to this claim. I have, of course, set out my submissions in writing. I have sought to encapsulate in these oral submissions what I have said in paragraph 39 following in the skeleton argument. I am obviously very happy to go through what I have said in those paragraphs, but
that's not necessary.
No, and I do, with respect, commend to the court the reasoning of Mr. Justice Kerr, which I have quoted in paragraph 50 of my skeleton, which of course is paragraphs 160 to 167 of his judgment, particularly paragraph 166, which I understand to have been the sheet anchor for his decision in this case, that rejecting Mr. Bewley's complaint under this ground, and I have sought to, in my oral submissions, to unpack why it was that the judge wrote that paragraph in the way that he did.
166.
166.
Yeah. Yes, right.
I should perhaps just say there was some passing reference to the making of some temporary traffic orders. Those orders would not, on the statutory regime that governs them, would not have allowed the process of information gathering and experiment after the making of the order that is part of the statutory scheme which governs the procedure for experimental orders under Section 9. And so there is in fact an advantage, a relative advantage in the Section 9 procedure in once one accepts, if one does, the dichotomy that I have put to the court between which arose in this case in the light of the specific circumstances of the Secretary of State's statutory guidance in May. That is to say, the need for urgency, while tempered by the need to ensure that the impact of the orders made urgently was properly understood with information gathered from the local community and so forth. The December report, this is the final point, the December report, I haven't referred to that, and I don't place any particular reliance on it in response to Mr. Bewley's claim. The reason I just want to be clear, it's not because I accept the constitutional, the report is constitutionally, sorry, the decision is constitutionally suspect, but for this reason, if you're against me on the October report, I cannot, as I see the treatment of equalities in the December report, I cannot resort to that if you like to save the situation.
No, and you don't seek to do that.
No. So I am content and accept that the court's focus should properly be on the validity of the director's performance of the Section 149 duty in October. And unless I can assist the court further, those are my submissions.
Yes, there is just a question, I think, which lurks from the hearing below, and that is the concession that declaratory relief would not be caught by the time limit on the statutory challenge. Was that conceded, first of all?
Yes, it was indeed. I think I think for the reasons, I think the judge has correctly encapsulated what I said in the relevant paragraph of the judgment.
Can we just look at that?
Yes.
Sorry, I don't have in mind the paragraph number.
This is the section under the heading Preliminary Matters, beginning at paragraph 101, 69 of the core bundle. I think the concession is recorded at paragraph 108, which records me as having been prepared to contemplate.
Yeah.
That the court could grant limited relief in relation, provided it was confined to a declaration that the public sector equality duty was breached.
Is that supported by either the provisions of the Act or by any authority?
It's certainly not, as far as I'm aware, not supported by any binding authority. So far as the provisions of the Act are concerned, we do have those in might we just go to those briefly in the authorities bundle?
Yeah.
They begin at page 23 in tab 1.
Paragraph 37.
Yes. It certainly an order, that is, in this case, the oval triangle orders made without authority in September, those orders could not be questioned in legal proceedings. The basis upon which the statutory challenge is available is set out in paragraph 35 on page 24, which is a familiar form of words which confers a right on a person desiring to question the validity of an order on the grounds that it's not within the relevant powers or that any of the relevant requirements have not been complied with. Those terms are defined on the previous page in paragraph 34. And in particular, the relevant requirements are confined to the requirements of the Act or of any instrument made under it. So, although there's an ouster in relation to legal proceedings, which gathers some contextual definition from those earlier paragraphs, it had seemed to me that didn't obviously rule out, as a matter of jurisdiction, a claim not challenging directly the validity of the order or any or of the performance of the procedural requirements within the Act or any instruments made under it, but rather the freestanding duty under the 2010 Act.
But
So
a
the
breach-
declaration would... Sorry.
No, please
I was
finish.
going to say the declaration would obviously be limited not to any direct pronouncement on the validity of the orders, but rather as to whether the director had fulfilled his duty.
But then if the declaration was to the effect that the public sector equality duty had not been lawfully performed, would that not be a collateral challenge to the validity of the order itself? No?
Well, I see the force of that. I mean,
what would be the consequences of the duty not being lawfully performed?
The consequence would be that the council would need to revisit that question.
Yeah, but what would be the consequence for the order?
The order would stand. It wouldn't. By definition, the order, because that would be the inescapable consequence of the ouster.
Doesn't one need to look at the provision? Doesn't one need to look at paragraph 37, because that says, except as provided by the schedule, an order shall not, either before or after it's been made, be questioned in any legal proceedings whatever.
Yes.
So, regardless of the bases on which you are permitted to challenge an order, why isn't an application for judicial review brought outside the 6-week time limit for the questioning of an order in legal proceedings?
Well, I had seen at least the argument being available that it was a challenge not to the order, but rather on analysis to the performance of the public sector.
Well, that's why I asked you the question I did. Maybe my lady is closer to the point than I am, but I'd just like to pursue the point I'm asking you, which is if the public sector equality duty was held not to have been lawfully performed in a given situation, what would then be the consequences of that holding by the court for the order on which emanated from that unlawful consideration?
Well, I have to accept that it would, in the light of paragraph 37, the consequence would be that the order would be unaffected.
Right.
Now,
unaffected?
Yes.
And for the avoidance of doubt, I'll accept that. I can say something else.
Right.
But I mean, in a sense, I'm arguing against myself here.
Well, I know, but I mean, we need to understand what the law is.
Yes. Well, I had simply. I'm not trying to.
Section 149 applies to the exercise of any function. The function here is the making of the order. If the Section 149 duty has been breached in the exercise of that function, the normal consequence is that the exercise of the function is unlawful and the decision would be quashed. I mean, we were shown earlier on today the passage from Bracking in which Lord Justice McCone said the normal consequence of failure to comply with Section 149 would be that the decision would be quashed. So at the moment, I'm really struggling with the idea that a challenge based on an alleged breach of Section 149 doesn't fall foul of the prohibition in paragraph 37.
Yes. Well, let me see. I'm not trying to shrink from that, and I accept that the concession I made, which was made in the circumstances where I had myself pointed out that a proposed settlement was itself out with the jurisdiction of the court, because it would involve the court taking on the jurisdiction which it didn't have to essentially to quash the orders by consent, notwithstanding that the 6-week period for challenge had expired. That I was looking to see whether there was any residual room for the court to review any aspect of the decision-making process in relation to the orders, particularly where the focus of the challenge that Mr. Justice Kerr was being asked to consider was in relation to the performance of the public sector equality duty. And I had in mind that there is, as you will understand, there is, at least from one perspective, an element of unattractiveness about a local authority acknowledging that it has made orders that at the time that they were made without authority, and then saying, but there's nothing that can be done to retrieve that position.
But that's Parliament's decision.
Yeah.
Well, so be it. I mean, I am not, ultimately, it doesn't serve my purpose to seek to defend the limited and cautious concession that I made.
No, I mean, many instances of time limits not being complied with, often entirely innocently, usually entirely innocently, is that an apparent injustice survives. And the governing principle that pushes back against that is that legal certainty is sometimes, often, in our law, paramount.
Indeed.
And Parliament has so decided in a number of instances where exclusionary clauses such as paragraph 37 are enacted. We all know that. And sometimes authorities rely on that with alacrity, sometimes with reluctance, but the law is the law.
Yes. Well, my Lord, I, of course, accept all that your Lordship has said, and I, as I say, in making the limited and cautious concession that I did to the judge, I was, notwithstanding those points, looking to see whether there was some route whereby, at least in jurisdictional terms, some part of the claim that was being advanced could be saved. Perhaps I was doing more than I should have done in that respect, but nevertheless, I hope I've explained that that was the motivation for it, and I am not able to point to any authority to support me, perhaps unsurprisingly in the light of the way that the court has, the points the court has put to me. And I don't say that one can see with any degree of clarity support for that approach in the statutory provisions that I have put to you, that I've just shown you. And so if the consequence of that is that the court is disinclined to do other than to approach the matter in the orthodox way that your Lordship has put to me, I do not seek to maintain the concession. And it certainly doesn't, it's and the consequence would be that that insofar as any meaningful, insofar as the opportunities for relief in this case, in the event that the court was with Mr. Bewley on the substance of his claim, relief would be confined to the orders that were made in relation to Streatham Hill and Railton and St Matthews.
Yes. Yes, whether there are other things that the council could do in those circumstances is another question.
Yes, and there are issues about, essentially the doctrine of ratification if in relation to any criminal proceedings that might be brought and so on. But none of that need trouble this court.
No. Well, we will reflect on that in the light of your submissions now in response to our question, and anything that Mr. Bewley now says, which, as far as we're concerned, can merge with your reply.
Yes, so I thought that, and I might pick up on it straight away.
Is there anything else you want?
No, that was all. Thank you.
You want to raise something further?
So I'm
yes.
So in light of the exchange, I thought probably the sensible thing to do is to deal with that straight off.
Yes, by all means do. Yes, but take it in your own course.
Yes. Well, if you may still have open, because Mr. Mole took you to it a moment ago, paragraphs 106 to 108 of the judgment below, and I mean this is in part this is just to reflect upon the fairness of Mr. Mole's dealing on this issue, but perhaps just for a bit of context. So as you can see from paragraph 108, just to give you the context briefly first, you can see from paragraph 106 first of all, first sentence, to add further complexity, the parties had agreed a draft consent order inviting me to quash the orders constituting the Oval Triangle. That's correct. And a bit of additional context which is perhaps worth knowing is that that draft was effectively agreed, or nearly agreed, I think, I can't remember exactly, just before effectively Mr. Mould on the one hand and I on the other came into the case, because he may have seen that the original pleadings worked by others.
Yes.
And Mr. Mould, for obvious reasons, I'm not sure I'd turn my mind to it directly, I've just been told it had been made. Mr. Mould pointed out the potential problem with that, and on reflection, as you know, and it's called in paragraph 107, I didn't see a way around his basic point that he quashed the order and didn't seek to develop one. And so, but he was prepared to make the concession very fairly in the circumstances just outlined. And obviously, in those circumstances, I was content to accept it. That doesn't in itself answer the question for the court, but that's the context. As to the substantive point, and you may also have paragraph 37 of the schedule still open in the authorities. I mean, I don't want to pretend that I, like Mr. Mole, don't see any difficulties, but the way I think it can be put is follows. Nor do I say that there's any authority directly on point. The way I think it can be put is as follows. I think this broadly reflects the basis on which Mr. Mould made the concession. So what paragraph 37 does is it protects, it's an ouster, it protects the validity of the orders. For our purposes, the relevant orders are those for Oval Triangle, which, if you recall, are made in September. I think it's the 14th, at a date in September. But what happens is then that there was no underlying, as you've picked up, is that there's no underlying decision to make them. What then happens is that on the 9th of October, the council, Mr. Somney, makes the decisions which do authorise the making of the other low traffic neighbourhoods, the other environmental traffic orders, and which purports to authorise the Oval Triangle orders. Now that is on its face a decision or a purported public law decision. It's not, as it turns out, critical to the validity of the thing it's purporting to authorise for the reasons, and it may have been as at the 9th of October, but it certainly wasn't shortly afterwards. But it's purporting to do it, and the general principle, of course, is that orders, decisions, public law decisions are valid until quashed.
Yes.
And as a purported public law decision, not I think void, so obviously unlawful to be void. It is amenable to, it must be, as a separate matter, it must be amenable to judicial review. Now, because it is not necessary to underpin the orders which are now protected by paragraph 37, I accept that any decision the court makes about the validity of that 9th October decision in relation to Oval Triangle won't affect that validity. But it still stands as a purported public law decision purporting to have legal consequences. So leaving aside equality impact assessment for a minute, I suggest it would be open to a court, to the administrative court anyway, to say, for example, what is in fact conceded. Well, that decision of the 9th of October is declared to be, or even quashed, insofar as it purports to be a valid exercise, a valid decision to justify or to authorise the making of the orders which were already made. The reason it would be unlawful in that sense is because it postdates the making of the order, and on undisputed principles, I think it wouldn't be valid in that sense. Now, I don't need a declaration of that kind for the simple reason that that much is conceded. It's conceded that it doesn't constitute a it's conceded that it doesn't constitute a lawful basis to authorise the orders, although there's no formal record of a court decision to that effect. But in that context, and where of course we are in any event considering the legality of the decision by reference to the PSED in other respects and for other purposes, and where I don't understand to be said you can draw any distinction between the various schemes, I suggest you've got to purport the position, you've got a purported public law decision purporting to exercise powers in a particular way, and it's legitimate for the court to declare, at least, and actually to quash, but I mean that wouldn't add anything once I don't worry about it, purporting to declare not only that it's an invalid decision because it was taken after the event, but also, if you are so persuaded, that it was an invalid decision for the additional reason that there was a purported exercise of functions that it didn't comply with the Equality Act duties. That's the way I think it can be put. I don't think there's any authority on it. It's obviously rather an abstruse point. One thing I think I would say is I don't, in this sense, I'm now arguing against myself. I don't think I do submit or agree with Mr. Mole that the consequence of such a declaration would be that the council would be required to look at the matter again in relation to Oval Triangle. It would be entitled to, of course it's entitled to anyway, and it might be thought to face an argument outside the legal sphere that it should do so, would be given an additional impetus by a finding of the court. But I don't submit that it would be that the council, one consequence of the declaration would be that the council would be required to revisit the Oval Triangle ETOs. That would, I think, contravene paragraph 37. So that's how I think the point can be put. It's not a point, as you know, that I was very happy to accept Mr. Mole's concession, and that's in a sense why we are where we are. One level, if you declare, or if you find in relation to Streatham Hill and sorry, I should say, so you could make that kind of finding that I'm inviting you to make without questioning the validity of the orders, which I accept is prohibited by paragraph 37. Now, it's right to say, if you find that there's a failure to discharge the equality impact duty in relation to Streatham Hill and Railton, implicitly it may be said, it may even be reflected in the judgment, that you would have found necessarily the same in relation to Oval Triangle, but for paragraph 37. Indeed, you could even say so, I suppose, without making a formal declaration.
Yes, the judgment will.
That's a matter for you.
Judgment in those circumstances would say what it had to say.
It would say what it had to say. So, whether a formal declaration then adds anything in any event query, but for the reasons I've outlined, we say I do make the submission that limited, and it is a very limited formal relief.
Yeah.
It might be said, and I think it would be said, but not I think by way of legal compulsion, that if the court were to recognise that, whether in a declaration of the kind I say you can make, or just in the judgment, that's going to have implications for the way the council approaches it next time round.
Of course.
You have to take that on board, and that's obviously one of the reasons we think it's a desirable end. We do it all in the context of being entitled to and bring the proceedings in respect of the other orders. But that's how I can put the point.
Yeah. Well, that's helpful. Thank you very much.
So sorry. There is one other thought that occurs to me. Just on the point about the limits of what paragraph 37 protects, it occurs to me, and it's the other way round, really, that there are authorities which make clear that in certain... No, I'm actually going to pause. I'm not sufficiently confident of what I'm saying without going back to authorities, so I won't develop the point. I apologise. I'll only trip myself up.
Well, don't make a submission that you're not confident.
No,
in.
I'll stick rather than twist. That's right.
Understood.
So that brings me back to my reply.
Yes.
Turn up the page. Yeah. So I hope I'll be pretty brief. Barristers always say that. 5 points. Short first point, Mr. Mole points you to paragraph 85 of the violence against women case, and the thrust of what he says about it, I think, is it's paragraph 85 and 86, but I think the key point in a sense is a sentence. The judgments, various earlier judgments, including Bracking, should not be read as if they were statutes. I obviously accept that. It's very often stated about many judgments. What I think it means is that you don't approach the task of divining the legal consequences of a judgment in the same way as you do with a statute. And in particular, what you don't do is start trying to pass the language of the judges use. And if ambiguities arise, it may be better to go back to first principles rather than treat the language, the particular words used as authoritative. It's something of that nature at any rate. What you can, of course, do is treat those judgments read them as if they were judgments, because that's what they are. And it's well established in our law that judgments are a legitimate way of setting out legal propositions. Bracking sets out a number of baseline legal propositions. They are all completely consistent with the separate proposition, which I think is actually probably reflected in Bracking, but in any event, plainly right, and I've accepted it already, that context in this sphere is very important. That's also true. But saying that context is important isn't inconsistent with those legal propositions. And for example, because this is the one that's become particularly of interest, it's not inconsistent with saying that the decision maker must take account of the relevant the factors for themselves. So in other words, what context can do is tell you something about the nature of the analysis that has to be undertaken. But it doesn't, in my submission, and certainly in all but the most exceptional cases, it doesn't affect who has to undertake the analysis. So in a budget case, such as Hollow, the analysis will be much shorter. It still has to be undertaken by the decision maker. It doesn't alter. That's the first one. Secondly, coming to that proposition in particular, I pointed you to the paragraphs in Bracking which support it, that the decision maker must balance the relevant factors for themselves and so forth. He can't. I say that's correct. I say it's correct because there's a decision of the Court of Appeal in front of you that says it's correct. Query obiter, it says it in two different ways. I've shown you the paragraph 26.3 on the one hand and 26.5, Roman 4 on the other. They're saying effectively the same thing. There's a question mark, I know, about whether we ought to be looking at some of the underlying authorities, and I'll just park that because I can't do it now. But what I'd just invite the Court to reflect upon for a moment is why actually, just as a matter of first principle, it must be correct in my submission. And the reason for that is as follows, and it may be sensible, just have in mind, yes, I think it would be sensible to have in mind the relevant paragraph 7.2 of the October report, which I think I have now established. It's at tab 11 again. I think I have established that the page number which the court will have is 233. This is not the number that I have. Before I make the point about 7.2, just invite the court to reflect back for a moment on what Section 149 is doing. What Section 149 is doing is not requiring that decision makers or anyone else, statutory bodies, carry out a separate and freestanding exercise of balancing out equality considerations, and then having ticked that box, go on to make its decision by reference to the other relevant considerations. Rather, what it requires, what it does, one way of putting what it does, it's not expressed in this way often, but I think I have seen cases where it's expressed, is that it makes the consideration of the equality matters which are set out a mandatory relevant consideration in reaching the decision. In other words, the decision maker has to balance those matters as required, whereas he would previously only have been entitled, required to balance those matters out, to the extent relevant, against the other relevant factors in the case. And so that's why it's said, and it's quite, one sort of skips over the language in judgment, but that's why it's said that the equality duty is integral to the decision-making process. It's not just sort of Pierce language. It means that you've got to integrate the factors that equality duty requires you to have regard to and balance them out against other factors. Now think about that in the context, for example, of paragraph 7.2. All that Mr. Dissonmu has been told is that this person, the assistant director, has approved the project team's assessment in turn, so there's approval of another assessment. That there's a reasonable expectation that the measures will not disproportionately affect people with one or more of the above protected characteristics. But of course we don't know, that's a black box. I'm going to come back to that in a minute, because the black box in more than one sense. We don't actually know whether that means, well, the project, and certainly Mr. Dissonmu doesn't know, whether that means that the project team have concluded there are no adverse impacts, or whether it's that they thought it was a finely balanced, but on just about, it was just about proportionate, or the one just about outweighs the other. Now, we don't know that. Mr. Dissonmu doesn't know that. And therefore, he's got no basis upon which he can understand how that aspect is integrated into the rest of his decision. So just as he has to, it's a basic principle, the decision maker is the person who has regard to all of the relevant factors, that's what it means to take the decision. Just as the decision maker has to balance out, for example, the factors in section 122 of the Road Traffic Act, which we haven't looked at but you'll have picked up, also makes certain considerations mandatory, and any other considerations he considers relevant. He has to balance out the equality impacts against those other considerations, and he can only do that if he's informed himself of what those considerations are in their substance and the weight that he should, and therefore able to form a view about what kind of weight should be attached to them. And that's why in other words, it's no different from if it's okay for him to say, well, I accept the Assistant Director for Highways has approved the project team's assessment that the equality is okay, the report might as well say, well, the project team have also included that the Highways implications are okay, and therefore I don't need to look at that either. It's no different. It's the decision maker who has to balance out all these considerations. That's just what being the decision maker means. Obviously, he can get help, he can get reports, he can get advice and so forth, but he must, for himself, consider the various matters. That's the second point. Third point, just come. Mr. Mould made, I think, quite a lot of this, and I want to take it quite quickly. But he characterised, and I may have misunderstood his submission, so I'll take it shortly. We'll see. I think what Mr. Mould at one point was seeking to do was to characterise the decision in a particular way. He sought to characterise it not as simply a decision. I don't think he denies it's also this, but not just as a decision to approve the schemes under Section 9, but in a sense as a decision to depart from the previous proposals to do it all under Section 6, at which point you have a permanent order. Of course, you have to go through the statutory consultation requirements and so forth. Now, I suggest that's slightly over egging the pudding. In some sense, that's what Mr. Disomno is presented with, and he's invited to approve these schemes of experimental orders. He's obviously aware, as I've already accepted, experimental schemes are being required to approve, but it's not obvious that he's making the decision that it should be done by way of experimental rather than other. But in any event, in a sense, that's by the by. Because it's made under Section 9, plainly it's right that the statutory consultation requirements in Reg 7 and 8 are disapplied. That's obviously right. I've accepted that. I showed you the statutory provisions which have that consequence, namely secondary legislation. But that secondary legislation, which first imposes and then takes away, so imposes in relation to orders generally and then takes away in relation to experimental orders, consultation requirements, can't fundamentally alter the nature of the separate requirement imposed by Parliament under Section 149. It just doesn't have that effect. Indeed, it might be said, I don't think I need to go this far, that the very fact that you aren't doing the consultation, aren't undertaking consultation, makes the need to comply with the Section 149 duty all the more acute, or at least means the need to take care in your inquiries is all the more acute because you know you're not going to get assistance from consultees. So, whether Mr. Mould is right that that's how Mr. Disomno saw it, I suspect he's wrong, but it can't fundamentally change the character of the Section 149 duty. That's the third point. Fourth point is a very, very short and factual point, and I'll make it very. Mr. Mould made the point in various different ways, and I'll make it very shortly. If you just go back in the report for a moment, and there are a couple of examples. Let's go for example to paragraph 2.11. So that's, I don't know what page number, I'm afraid.
Don't worry.
I'll be too risky to guess. But it's 2.11 in the October report. So
Page 222, so it happens.
great, thank you. So I think Mr. Mould drew attention to 211 as one example among many of the council making alterations to the scheme, to the particular schemes, to deal with particular issues. And so 211 is an example of that. To reduce the degree of travel disruption for residents of the Mercer estate, it and Albert Avenue will be accessed from Clapham Road. So there's a recognition of a particular problem arising from the particular layout of the scheme, which has led to a modification. Well, one of the things the public sector equality duty requires you to do, effectively, or in the context of this case, obviously requires, is to think about whether those kind of adjustments dispensation or exemption is an appropriate thing to do for a particular category of disabled, or protected characteristic, disabled person. But of course, that's not done. It's pretty striking that when you come to the exercise in relation to particular residents or people living in particular places, the exercise is done. That exercise, which could plainly have been done for disabled persons, indeed it's now accepted, doesn't really, as I've already submitted, depend upon what comes out of the experiment to a marked extent. That exercise was never undertaken. And that's, and again, in a sense, it points back to why it was important that Mr. Dissonmu was provided with the underlying material. Because he might have said, I don't know, but he never had the chance. Oh, I hadn't appreciated when I read the report, but I appreciated from the equalities impact assessment that there is a particular problem for certain disabled people, those reliant on cars. Hold on, shouldn't we think about mitigating that? I'm troubled that the equality impact assessment didn't do it. But I think it's an important point. Now, I don't know if he would or wouldn't. But again, it makes a point. The analysis wasn't undertaken, certainly by him. He's never given the opportunity. In fact, the analysis hasn't actually, the reality is the analysis hasn't progressed to that stage even in the underlying reports. Last point of reply. We come back, sorry, I've dotted about a bit, come back to 7.1 to 7.3.
Yeah.
It's a key passage, everyone agrees. What Mr. Moulds said, fairly close to the outset of the submission, is that the duty was discharged because Mr. Dissonmu was given two pieces of advice on which he was entitled to act. And the first piece of advice we needn't go back to, but it's 4.16 to 4.17 of the report. That's just the legal advice. You've got to comply with the duty. I mean, I don't criticise it. For the avoidance of doubt, it's obviously not the most complete statement of the duty ever. We can't assume that because he was given that advice, he knew everything he needed to know about the duty. But anyway, he didn't, for example, necessarily told that he had to balance out the considerations for himself. But anyway, so far as it goes, there it is, but it can't by itself be the solution to the case. The other advice, see what it is. It's really 7.2. There's a bit of it in 7.1, but let's focus on 7.2. Same point, really. So the Assistant Directorate for Highways, Capital Programmes, etc., has approved the project team's assessment that there is a reasonable expectation. So the advice he is given, we just need to see what the limits of the advice is. The advice that he is given is not that the quality implications are X, Y, and Z, are provisional views that can be balanced out in a particular way or mitigated in a particular way, whatever it is, and therefore we think it's proportionate. Do you agree? The advice he's given is limited to someone else is satisfied. And someone else has approved someone else being satisfied. We don't know the relationship. In my submission, for the reasons I've given really, that advice, that's Mr. Mull's case, he says, just giving of that advice that someone else is satisfied is enough, but that's just inconsistent with the authorities. I said there was another respect in which there's a black box here, because obviously there's nothing in 7.1 to 7.3 which is itself a substantive consideration of the equality impacts. Because I can make that submission, that's the submission I focus upon, because the key to the case in my submission is that Mr. Dissonmu didn't consider the matter. There is actually something else pretty striking. If I invite the court just to think back to all of the authorities we've looked at, and I think every equalities impact assessment case I've ever looked at, what one expects to see, whether it be by contemporaneous record or absent a contemporaneous record, which is good practice but not a necessity, perhaps a witness statement or some explanation about how you can, by inference or contemporaneous evidence, whatever it is, be satisfied that the duty was complied with. It's not just a statement that the duty is complied with somewhere, but something that shows how the factors were balanced. Now, even if Mr. Mould can get past the point that it's the assistant director approving the project team and not Mr. Dissonmu at all, that's obviously my first point I'd emphasise. There's nothing which enables the court to satisfy itself that the assistant director or the project team's assessment was a satisfactory one. Because actually, when you go back, it's not that we're provided with any contemporaneous record. We've not got a witness statement from Mr. Tsongo, nor do we have a witness statement from the Assistant Director saying, these are the factors I know. And there's nothing contemporaneous, certainly not from the Assistant Director. All that there was in existence at this stage, certainly in a respect that reached any moderately senior level of the Council, is the Railton only, so it doesn't even deal with the other areas, the Railton only EQIA. And that was in draft and hadn't even been signed off at that stage by the project team. So the basis for this statement is wholly unclear. I don't therefore invite the court to conclude necessarily that it's untrue, in the sense that by the by. There is nothing before you in my submission that would enable you to be satisfied that the assistant director or even the project team had due regard any more than Mr. Tsongo. The issue is whether there was due regard. What the court ought to be presented with in those circumstances is something that shows, I say by Mr. Tsongo, but if I'm wrong about that, by someone else, how the factors are balanced. And there's nothing. In those circumstances, especially say, the finding should be that the council in the challenge is made, though Mr. Tsongo is the council, via Mr. Tsongo, has failed to discharge its central duty. And that's those subject to any questions, etc. Those are my submissions.
Thank you very much. See if my colleagues have any questions for you. Oh yes. I think the door is ajar, probably, or at least we haven't closed it, for anything that either side wishes to say about the decision of or the judgment of Lord Justice Sedley in the case referred to in paragraph 26(3) of Bracking, whose name I've now forgotten.
Society of Health or something.
Yes.
So,
Health food, something like that.
I think any submissions on that, subject to my colleagues' views on this, should be with us within 7 days.
Yes. As I understand it, and please correct me, the door is open, but nothing is required. Although obviously,
well, the door is open. The door is open. I mean, we shall, if nothing comes through the door, we shall, in any event, of course, be looking at relevant authorities and reflecting on them.
I'm sure I'm going to look. If the conclusion I reach is I've got nothing to add, then I'll tell you. And
but we're not seeking to open the whole thing up. I mean, it must be very tightly confined to any observations about what is said by Lord Justice.
Can I? Yes, just on that. I mean, if the issue is going to be looked at, I would want to look at the legal issue rather than just the case, because it seems. I mean, if the case doesn't resolve it, but I think, well, there's actually another. Is that permissible? I'm not anticipating.
Well, I mean, we've raised an inquiry about it. There hasn't been an opportunity in the course of the day to investigate it. You must use your reasonable discretion.
Yes.
I mean, I won't say more than that.
I don't anticipate burdening you with 20 pages.
This is not an opportunity simply to reventilate arguments. That will not be well received by the court.
Of course.
We also shall reduce the information I gave you at the beginning to.
Yes.
To write
oh yes, if you would, yes.
To a note.
Yes, that too, please, within 7 days.
Yes. Fine.
Which seems a reasonable time in the circumstances.
Thank you.
Yes.
Anything else, Stephen, you want to ask? No, well, we have no further questions. Thank you both very much indeed for your most helpful oral and written submissions. And we thank the legal teams who've assisted you as well. It will not surprise anyone who has attended this hearing, either here or remotely, to hear me say that we shall reserve our judgment. That will be handed down in due course after a draft of it has been circulated for typographical and any minor factual corrections, not for any observations on the content in any substantive way. The arrangements for hand down will be conventional. We shall expect a draft order agreed if possible, and any submissions on related matters in advance of hand down on the timescale that will then have been indicated. Thank you very much.